Okay, is everybody here? Right, let's start. What I'm going to talk about today is civil and criminal courts within the English legal system. Civil courts resolve disputes between private citizens or between private citizens and the state. In the criminal courts, cases are brought against a person who has broken the law. These cases are usually brought by the state. It is important to know the distinction between the cases that are heard in the civil court and the cases that are heard in the criminal court. So in this lecture, we're going to look at the differences and also where there is an overlap. We'll then take a brief look at tribunals and establish how these differ from civil and criminal courts. Let's look at some examples to highlight the differences between the types of court. Firstly, trespass. A trespass is a tort. So the sign to deter unwanted visitors that you may have seen on a gate, "Trespassers will be prosecuted," isn't correct. What's wrong with it? Remember, you can only prosecute someone in a criminal court, and trespass is not a crime. It's a tort. A trespasser would be sued in a civil court, and the court would normally order the defendant to pay damages. Or, in certain circumstances, the court might issue a prohibitory injunction to prevent the trespasser from going onto the plaintiff's land. If there was a breach of the injunction, the trespasser would be in contempt of court, and the case would be heard in either the county courts or the High Court. What about assault? Well, assault is both a crime and a tort. In a criminal case, assault is usually defined as any act which intentionally or possibly recklessly causes another person to apprehend immediate and unlawful personal violence. Apprehend means to understand that something is very likely to happen. Battery, on the other hand, is usually defined as the intentional or reckless application of force on another person. If you deliberately bump into someone in a street, that would be actionable. But if the street was extremely crowded and you had no way of avoiding it, that would be part of acceptable social interaction and would probably not be actionable. Theft is a crime and is defined in the Theft Act 1968 as dishonestly appropriating the property of another with the intention of permanently depriving the other of it. Here is a situation which, sadly, some of you might have experienced. A student was on his first visit to the UK and was unfamiliar with the currency. He took a taxi and paid the driver what he thought was the correct sum of money. The driver indicated that he needed more and took notes from the student's wallet that amounted to far more than the actual fare. The driver was convicted of theft and appealed on the grounds that the victim consented to the money being taken. The appeal court judges rejected this argument because the student only consented to the legal amount being taken. Cases brought before the civil courts are to do with legal matters such as breach of contract, trespass to property, and disputes over land or the wrongful exercise of power by a public authority. Cases are usually cited with the names of the parties to the dispute. For example, Miller and Jackson. This is written Miller v. Jackson, but said as and. Miller and Jackson. In civil cases, the court can award damages to the person who has suffered as the result of wrongdoing. In certain circumstances, the court will issue an injunction to prevent the wrongdoing from occurring again. Cases brought before the criminal courts are to do with offences against the state, which, these days, usually involve breach of the statutory law. In the UK, cases in the criminal courts are cited as R. v. Smith. R stands for Regina, or the Crown against Smith. When lawyers refer to criminal cases, they often use just the name of the accused, for example, Smith. If the accused is found guilty, the court can order punishment. This can either be a custodial sentence, which means going to prison, or a non-custodial sentence such as a fine, probation, or a community service order. Remember that a court is different from a tribunal, although the distinction is not always clear. The House of Lords decided in the Attorney General versus the BBC 1980 that a court exercises the judicial power of the state. If it only has an administrative function, it is not a court. This distinction is not merely semantic, as it has a direct bearing on contempt of court proceedings. Contempt of court, by definition, applies only to courts of justice and not to other legal decision-making bodies. It has been held that an employment appeal tribunal, which would hear cases of wrongful dismissal by an employer, is a court, yet there can be no contempt of court in a tribunal. So, to summarise, in the English legal system there are three different types of court: civil courts, criminal courts, and tribunals which act as courts. We have looked at the cases that are likely to be heard in each type of court. Trespass is a tort, and the plaintiff will sue in the civil courts. Assault can be both a crime and a tort, and the case could be brought in either the civil court or the criminal court, depending on the circumstances. In a civil case of assault, the plaintiff will sue for damages, while in a criminal case, the police might charge a person with grievous bodily harm. Theft is a crime, and cases of theft are heard in the criminal courts. Tribunals which act as courts and have a judicial rather than administrative function include the Employment Appeal Tribunal. This tribunal would hear cases of wrongful dismissal by an employer, for example. OK, that's it for today. Next time we'll look in detail at trespass to the person. And don't forget to do a bit of research on that before you come. Thanks. See you soon.